Good evening, everybody, and welcome to this first medical legal webinar. We are with Dr. Neeraj Nagpal from Chandigarh. I welcome you, sir, and request you to go ahead with your talk on when I receive a legal notice. What next? Welcome, sir.
Thank you, Dr. Ashok. It is a pleasure to be with you. The topic I thought to start the sessions is if you receive a legal notice, what next? Because most of the doctors they panic once they receive a legal notice and do not know what to do and tend to make mistakes once they receive a notice. So exactly what has to be done when you receive a notice? The first step is take a deep breath, ask for a glass of water, ask your receptionist to give you 5 minutes, go through the contents of the notice, and please note, is it from an advocate? Is it from consumer court? Is it from civil surgeon office? Or is it from state medical council? All these have different implications. You may even get a notice or a letter from the patient directly claiming that you have committed negligence and you should compensate and do this and do that. So each of these has a different implication, and you need to be very, very clear. If you find that it is the patient who has sent you a legal notice or a letter, uh, it is not mandatory that you respond. You may respond, but it is not mandatory. Supposing this is from an advocate, then under those circumstances, also it is not mandatory that you respond, but we do advise that some kind of response is given. If it is from consumer court, you have to prepare yourself well before you respond. Is it from civil surgeon office? Sometimes a simple letter will come from a civil surgeon office that we have received a complaint against you. Kindly come for to present your side of the story before so such and such doctor. Doctors tend to take this lightly, but actually this is a very, very serious matter when a notice comes, a letter comes from the civil surgeon's office or from the health, from the director health services office, because the Jacob Matthew judgment of 2005 had mentioned very clearly that criminal prosecution of a doctor cannot start if a medical board's opinion has not been taken. Now, usually this meant that patient would file a complaint with the police, and then the police would ask the civil surgeon to form a medical board, and that medical board would inquire into the circumstances of the event and would say whether there is negligence or no negligence. And in case they say there is negligence, then police would register the FIR and proceed from that point onwards. But now there is a tendency also to make complaints to Chief Minister. There is a tendency to make complaints to the Health Minister, and the Health Minister and the Chief Minister simply mark the complaint to the local civil surgeon, and the civil surgeon then calls up an inquiry. The problem with this inquiry is it's taken lightly, and if you do not represent yourself well, and if you are unprepared, and a negative report is issued, this in itself will be taken as evidence of negligence, and a criminal prosecution may start thereafter. So this is not to be taken lightly. Similarly, so from the state medical council. If you have received a notice from the state medical council, it is to be taken with the utmost seriousness. A criminal case, however, does not start with a notice. Usually, a criminal case will start with the appearance of a policeman at your clinic or at your hospital, and this policeman will hand you over a summons, which may or may not contain the FIR copy, which may or may not contain the complaint copy, and will summon you to come to the police station to answer the questions. So the question arises, what should a doctor do when he gets a notice from an advocate alleging medical negligence? Now, whether it is from the advocate or it is from the patient, the process to be followed remains the same. First step is do not panic again. The most important thing to be done at this stage is inform your insurers, the indemnity insurers in writing via email plus via registered post, preferably also on receipt when delivered by hand. Retrieve all the medical records and study them. Prepare a story of what happened in short and why the adverse outcome was not your fault. Also prepare a point-wise reply to all allegations. Research references to be provided to the advocate, to your advocate after studying and underlining the relevant portions. Discuss with seniors and colleagues. Doctors have this tendency to hide the problem and they feel if they discuss it with somebody, they will become a laughing stock or they will be other people will take a professional advantage of them. But remember, everyone is not your enemy. There will be seniors, there will be colleagues who will be wanting to help you, who will help you and discuss with them. But after doing all this, do not send this as a reply to the legal notice. Where the reply that you format, which you send to the advocate or to the patient, if at all you do, it should be bland. Denying any liability, denying any negligence, claiming to have done the work absolutely ethically and professionally with the best of competence and with no negligence. Each point wise reply can be given that this allegation is denied, point number one is denied, point number two is denied, without going into too many details. Because the reason I say this is, number of times we have come across a situation when the patient is writing to the doctor or when the patient's advocate is sending a notice to the doctor, the allegations made are different. And once we have replied to those allegations, by the time they take the case to court, they form new allegations which were not part of the original allegations which were made in the legal notice sent. So they improve upon the case depending on your reply. This is the one reason I always say do not disclose all your cards, do not disclose your entire defense initially only when you are giving a reply to a legal notice. So this is one of the basic questions that whether detailed reply should be given, and my answer to that is this should be avoided. But then, if the notice is from the consumer court, you have to give the totally detailed reference reply because you may not get a chance thereafter to improve the reply which you have filed in the consumer court on the first instance. So make sure that this is not done, that you ignore a notice from the consumer court. And how much time do you have to file a reply? The advocate may say file within 15 days, otherwise we will take such and such action. All that has no meaning. But from the consumer court, you have 30 days to file a reply and 15 days extension can be sought. So maximum 45 days. And if you have not filed within 45 days, as All India Institute of Medical Sciences and another this gynae, Dr. Suneeta Mittal versus Sangeeta Pandey case of National Consumer Dispute Commission, the right to reply of the right to file a reply of All India Institute of Medical Sciences was forfeited, and they had to be proceeded against ex parte, despite the case. The only reason being that they had not filed the reply within the stipulated 45 days. So this, so effectively, they could not file anything in their defense. The patient could make all the allegations and they were taken at face value, and this case was decided in this fashion. Similarly, in this case, though, against Base Hospital, patient developed paraplegia in a case of carcinoma breast following lumbar puncture, which was done without written consent. The OPs did not file the written version within the stipulated time, and the right to file a written reply was forfeited. This happened again with the base hospital people also. And insurance companies, if you go through the details which are mentioned in the copy of the insurance which you receive, they say very, very clearly that no liability can be fastened to the insurance company when there is non-adherence to the conditions of the policy. And what are the conditions of the policy? Notification of claim should be made by policyholder within 90 days, and since if this has not been done, the company is under no obligation to pay the amount. This has happened in 2010 in Andhra Pradesh State Commission. Many other cases have happened where similar fee has been taken. In this case, the doctor had insured himself for 10 lakhs. Case, the district forum awarded 2,67,000. After the judgment of district forum, the doctor decided to send a notice to the insurance company. I was insured with you, so kindly pay. The insurance company refused to pay. District Forum, State Consumer Dispute Redressal Commission, and National Consumer Dispute Redressal Commission all dismissed the petition of the doctor with the costs of holding the stand of the insurance company. So, point is very clear: before, not after. When you receive the notice, when the process starts, it is at that time you have to intimate to the insurance company, and that too by registered post, email, and on receipt, that such and such event has occurred. This is the notice I have received. These are the documents of the case file, and any other information which they want, you have to provide. Another similar case, Rajan Vikas Mittal Hospital, Sangrur versus National Insurance Company Limited. The code was that the insured shall give written notice to the company as soon as reasonably practicable of any claims made against the insured or specific event or circumstances that may give rise to a claim being made against the insured. Please understand this very, very clearly. What does this mean? This means that not only when you receive a notice, or if somebody has claimed 10 lakhs from you, or has claimed 20 lakhs damages from you, or 2 crores damages from you, not only then, but when that event had occurred, if there was a death in the OT, and people had made a hue and cry over there, people had threatened you telephonically, people had, the patient party had gone and made a complaint to the police, that is the time you should have intimated the insurance company. In this case, tomorrow a claim may arise. The claim has not arisen till the time the notice has come. That may come up to 2 years after the event. But the company wants you to intimate them as early as possible of any claim which has arisen or any event through which a claim may arise later. This is also very important because, one, the indemnity insurance which is provided in our country is claim based and not event based. To understand this thing, please understand this, that if you have taken indemnity insurance from, let us say, New India Assurance, and in their tenure from January 1st, 2017 till 31st December 2017, during that period, a death occurred, and you got a claim regarding that death, let us say in 2019. But in 2018, you changed from New India Assurance to United India Assurance. And when the death had occurred in 2017, you did not bother to intimate your insurance. The claim now comes when insurance is being given by another company, which is United India. Now the point remains, both the companies will deny liability. One, the first company will say, you did not intimate us when the event occurred, despite realizing a claim will arise out of this. And the second company will say that we were not informed of this event, which was likely to result in a claim when we gave issued the policy. So things were withheld from us. And plus, being a claim-based policy, it means the claim has to be filed within a particular period of the within the policy duration, or maybe up to 60 days or whatever period they have mentioned in the document after the policy period, which is grace, because supposing your policy is ending on 31st December and an event occurs on 31st December, obviously the claim is not going to be filed on 31st December. The claim may be filed up till, so the companies give a leeway of a few months, but that is not in consonance with the 2 years which a patient has to file a complaint against you following the adverse event. Problem is magnified because of something called discovery rule, which the Consumer Protection Act has, which the Supreme Court has upheld in Consumer Protection Act, which says the patient has 2 years after discovering that you had made a mistake or you were negligent in your professional conduct. What does this mean? 1993 you conducted surgery. 2002 they did an ultrasound to find out that a swab had been left in the abdomen. 2004 the case was filed, which means it is now 11 years from the time when the original event occurred. The insurance companies would definitely have changed. And now in this situation, the insurer which was covering during that event, the event with the surgery which was done in 1993, may not be providing you insurance today. So effectively, as early as possible, it is mandatory that you intimate the insurance company of an event which has resulted in a claim or may result in a claim at a later date. Look at this case. Again, the same kind of situation was here. No intimation was given to company regarding death, FIR, acquittal in criminal case, because all these things happening immediately would have intimated to the company that this will result in a claim later. And tomorrow, when you file when you ask the insurance company to pay the compensation, the insurance company is within its rights to refuse payment. Similarly, again, told to pay compensation, which will be reimbursed later by the insurers. The insurance company was intimated verbally in this particular case, and they assured that we will make the payments. But after the doctor had made the payment and he wanted reimbursement from the company, then the company declined. No. So any communication with the insurers has to be in writing, it has to be by registered post, it has to be by email, so that you can take up the matter against the insurance company at a later date in case such a situation arises. And again, in this case, the stand of the insurance company was, upon occurrence of the event, giving rise or likely to give rise to a claim of this immediate notice to the company, and if this has not been given, the insurance company is within its rights to deny any claim. So the message from our side is intimate if you have death or violence to the insurers, intimate by registered post and keep a copy and receipt, intimate on receiving notice, summons, FIR, do not pay money without written authorization from insurance company, and deal with the insurance companies as a group, not as an individual. When you take individual policies from any insurer, you are at their mercy. When you take it through a group, like Medicos Legal Action Group, of which we have around 500, 600 doctors whose policies we take from United India. Similarly, there are many other groups which are professional bodies which are providing indemnity insurance after negotiating with various insurers. So these bodies of doctors, these groups of doctors are in much better position to deal with the insurance companies because they have bulk premium to give to the insurers. And their terms and conditions are not as stringently applied as against an individual doctor. So if you're not informing the company of claim, no insurance company liability, this thing I think we have stressed time and time again. no point in going into this. But this is something which, if one message can be carried from this talk today, it is that any event, any threatening phone call, any violence, any FIR lodged, inform the insurance company that this event is likely to result in a claim to be filed later. Once you have done that, after that, even if you change your insurers at a later date, it does not matter. Then this company is liable to fulfill. Only thing is, you should be able to prove that you had intimated to the company. Next question arises after receiving the legal notice. You have reviewed your medical records and you find lacunae in those medical records. Uh, what should you do? Many doctors ask me this question. And should you complete the incompleted records after you have received a legal or court notice? It is a very, very tricky situation. We are living in a time when everyone has smartphones, everyone has access to photographic equipment in their mobiles, and you will be surprised how many patients actually photograph the case files and go to other doctors seeking their opinion while patient is admitted in another hospital. So if somebody has already got a document, photo already has a document which is photographed, and tomorrow you make an alteration in that and present it in court, this can result in much more serious charges against you, where fabrication of evidence in a case, whether criminal or civil, will lead to much more severe punishment rather than leaving the records incomplete. Here, in this particular case, Hindu Sharma versus Indra's Apollo hospitals, they mentioned very carefully, they mentioned very clearly that the original medical records, which clearly revealed tampering, cutting, erasing, manipulating, dosage of syntosnon, on bare perusal, it is apparent that records are tampered to the extent which show erasing marks, pinholes. There are some handwritten insertions, overwritings, discrepancies in doctors' and sisters' chart. This invocation of the maxim res ipsa liquidator is justifiable in this case. 1 crore was awarded, 10 lakhs was further awarded as a punishment for this fabrication of records. And the thankful thing was, for the fabrication of records, they did not prosecute the doctors and the hospital under criminal negligence. Otherwise, the charges against this would have been under various sections of IPC. Similarly, doctors, when they try to fabricate the records, there is no space in the medical on the page, and sometimes they will write an additional line in a curved fashion around the signature so that to make space for those letters. If you have to make a record, it has to be struck down completely, struck out completely. You have to write the date when you are striking it out. You have to write the new line. You have to write the date when you have written the new line and the time, so that it is very clear the reason for your deletion of something and what you have added and at what time you have added, and so that tomorrow you should be in a position to explain to the judges why you have made this alteration. Be very clear that such fabrication, such tampering, the judges, the judiciary is much more attuned to catching these things than doctors. So a medical board may overlook this, but the judiciary is very, very well versed in picking up such fabricated records. So best thing is not to indulge in tampering of the medical records after you have received a legal notice. Only exception could be if you are 110% sure the records have been in totally in your custody, and but these things don't happen. Next issue arises. Many doctors come to me, Doctor Oswile, 20 people were sitting and we settled the issue, we paid 1 lakhs and got this thing written that the patient party does not have any grievance against us, and now they have gone to court. So this early mutual settlement, which doctors are in the habit of doing, is something like this, where you are sitting on a railway track, relaxed, without realizing that the train will come anyway and at any moment. Some cases I would like to share where this thing has happened, where a settlement had been done, and after the settlement, the court case was still filed at a later date. This was a very famous Odisha nursing home versus Dr. Rekha Sahu. Again, obstetric case, and it's an old case, but the fact is very well highlighted, and we have number of cases even now, even to this extent that the agreement between the doctor and the compromise has been produced as evidence. If the doctor was negligent, that is why he has paid us this as settlement. So the settlement has been done for 1.5 lakh, and like in this case also, the lady said, we agreed for this settlement amount because we were advised that once you have this, it will be a proof that the doctor was. Tomorrow you can go to court and ask for a higher compensation. So question arises also that when does preparation for a court case start for doctors? You have to realize that a court case against doctors is something like your first matrimonial dispute. When you get married, you are going to fight with your spouse. It is given. And like you prepare for that, you have to prepare for a court case also. Yes. It is always decided on documents, and though any patient can be a potential litigant, but any adverse outcome is, if you want to target a particular type of cases, any adverse outcome should be treated as a potential litigation later. Any aggression, any threat, telephonic or verbal, should be treated as a potential litigation later. And any potential litigation, if identified, should have immaculate documentation. Make sure of this thing that your documents are well maintained. I cannot go into the entire talk on documents because that is another 1.5 hour talk. But make sure that your documentation is immaculate if you have these two situations. Supposing there is a OT death, get notes written by staff nurses, resident doctors, consultants available over there on file. Those who may have been involved in the event, if you do not get their notes on the file, tomorrow they may have left the institution and gone years later, while the case lingers in court, and it will then be no longer, once their notes are in the file, it will be the responsibility of the court to ask them to verify. If you have not taken their them to write the notes in the file, then under those circumstances, you will be responsible to bringing them as witnesses in your favor or asking them later to file affidavits in your favor. Similarly, when an event has occurred, getting affidavits of police regarding the case, if possible, is easier. Tomorrow, 2 years, 3 years down the line, it becomes very difficult. Even email consultations with other experts is admissible in court. You have had a problem, you have had a death, you consult your seniors if you have, let us say, not in a case of death, but in a problem circumstances where the patient is in ICU and sick, and you have consulted your seniors on email. Even those email consultations tomorrow are admissible in court. And here is one of the examples of that, where email consultations between doctors have been shown as evidence and as part of medical record, and they have been admitted by the National Consumer Dispute Resolution Commission. So the question arises, this we have already answered, but just as a quick check, When should you inform your professional indemnity insurers in writing? Day death on table occurs, day you get a notice from advocate, day you get notice from consumer court, day you compensation is awarded against you. Obviously, the answer is day the death has occurred on table. That is the day you are to intimate your indemnity insurance. How then should you choose your advocate after receiving a court notice? uh, this is something which is tricky. Mostly we depend on references of others, which may or may not be the right way. And after doctors lose a case, all doctors claim that their advocates were useless, could not understand or explain to the court the medical facts. But the facts are, doctors themselves do not take interest in the case. They depend heavily on insurance company to provide them a free advocate and then do not spend time and effort with the advocate to prepare the proper defense. They do not make personal appearances in court, do not provide medical references to advocates. The excuses I understand. We are busy people, we waste so much time in court, it is not worth the effort. But the problem is with the unlimited compensations coming up and with compensations being awarded more than what have been asked, plus the interests which have been recently awarded in different cases, it is very important that we fight these cases in courts to the best of our ability and do not do a half-hearted job of this. So, do not depend on free advocates provided by insurance. Do not depend on personal recommendations of people you know. If you have a personal friend or family member, he is usually the best. And use your scientific mind and temperament. Research the website of the National Consumer Dispute Redressal Commission or the State Commission or the District Commission where your case is. Look for cases of medical negligence there. See which advocates have fought other cases of medical negligence and been successful, and try to hire them. There is absolutely no point in choosing a senior Supreme Court advocate for a district court case and use an advocate who routinely practices in that particular court where your case is there. Next question is, if you are insured for 10 lakhs, should you contest a claim of, let's say, 50,000? Definitely you have to contest, because there is no, this is very well established that compensation more than what has been asked for can be awarded by the courts. Here in this particular case, total 3,200 rupees was the compensation asked for. The hospital kept on doing an appeal from one forum to another, and finally the National Consumer Dispute Redressal Commission imposed a cost of rupees 5 lakhs against the original compensation of rupees 3,200 against the hospital. Then, if there are multiple doctors involved, should we have single legal representation or multiple legal representations? Multiple legal representations can be helpful because they give two different advocates time to address the court from their point of view, which is for the doctors. However, this is true only if the advocates for different doctors are not in conflict with each other. If one is trying to put the blame on the other, then it is a problem. Things absolutely not to be done in court. Try not to go for shifting of blame. This happened in the Kunal Saha story in Supreme Court also. Conflicting statements in court. The surgeon says the patient was absolutely fit and fine when we took, and after anesthesia, suddenly something happened. The anesthetic says, no, the patient was gasping when we took up the patient for surgery, and it was a high risk situation. So these kind of conflicting statements in court will create a problem, and we have had many cases where such conflicting statements in court have created a problem. Can and should doctors defend themselves personally or use an advocate to defend them in court? Ideally, you should always use an advocate. Our experience is courts are not usually very lenient on doctors who deprive advocates from what the courts consider their justifiable professional charges. So much better that you hire a proper advocate and let him defend you rather than trying to defend yourself personally in court. We tend to make mistakes, we tend to get emotional, and we tend to speak in a language which is Greek to the judiciary, and that creates a problem. So much better to have an advocate whom you have interacted well with in courts to defend you. Then, should doctors attend individual court proceedings or depend on advocates hired to them? Answer is very simple. You should attend all court proceedings yourself. Can doctor who has not seen a patient give an affidavit in support of his colleague based on case records? Yes. If a case has been filed against you, I request you should go, you should request two, three, four of your colleagues, give them facts of the case and ask them to give their opinion whether what you had done they would have done in the similar circumstances or not, and whether they considered what you had done as against the medical protocol. Here in this case, five doctors had filed their affidavit in support of the case on the opposite party. The case was dismissed. Always try to give textbook references versus journals, and the common difference, the defenses that you can take in court is one, you could argue that you did not owe duty of care to the complainant, that this was a totally free hospital or this was a totally free setup and no charges of any kind had been made. Those kind of hospitals where no charges are made obviously are not covered under Consumer Protection Act. It is a different issue that for violation of fundamental rights, the patient may still go under Article 226 and Article 32 to High Court and Supreme Court for violation of their fundamental rights and seek damages there. But at least under Consumer Protection Act, you could claim that you did not owe a duty of care to the complainant. Could claim that you were as careful as a reasonable person would have been. This is once you give affidavits of other doctors practicing in the same field in the region, and they say that yes, they would follow the same protocol followed by you, and they do not find anything out of the ordinary. You could claim that your actions, did not cause the victim's injury. A problem arises today with advancement of medical sciences. A lot of things have come up which extend a person's life, and there is no cut and dry one event which can be said to be the cause of the deterioration or the death in a particular person. You have done, let us say, a Nichols procedure, and you have shifted the patient into ICU. This Nichols procedure has gone off perfectly, and for some reason, the central venous line was needed after 2 days, and while doing the central venous line cannulation, there was some kind of error, and patient developed pneumothorax and died thereafter. Now the question is the surgeon who had done the Whipple's procedure responsible? Vicarious liability may be invoked, but then this could be one of the defenses that it is not your actions which were cause of the victim's injury resulting in the patient's death. Similarly, you could try to prove that victim was not really injured in the way he or she claims. We have cases where patients have claimed that their lives have been destroyed, but then doctors have hired private investigators, gone into their lives and found out and proved in court that their lives had in no way been destroyed as described by them. There are certain other legal common defenses which can be taken in court, but these are usually the advocate's domain, so we'll skip these. The issue arises, can an adverse medical board's opinion be challenged? Definitely yes. Whether it is from the civil surgeon's office, whether the SSPA has asked any medical college to form a board, and this usually the medical board's opinion is done by the complainant party, because they claim the doctors have tried to defend their brethren, and hence a new board should be formed. So we have had cases where five medical boards have been formed one after the other, two giving opinion against the doctors and three giving opinion for the doctors. And after that, the court says we will not go by the medical board's opinion. That is there to help us, but that is not there to. We are not dependent on the medical board's opinion. Or can investigators be used to verify complaint? I just mentioned about this. This gentleman had asked for 5 lakhs for loss of love and affection of wife because she died, but the opposite party showed that he remarried within 1 year of death of his wife. Decided yes, this much cannot be the loss if he remarried within 1 year, and compensation was reduced from 5 lakhs to 1 lakh. Similarly, in this case, 6 crores was demanded after a LASIK laser surgery because the patient said that his life was destroyed and he could not study, he could not do, he could not work. So they hired a private investigator, and he went through everything, and he found out that the patient has completed higher education and presently employed full-time in private sector after his LASIK treatment. And this, in the court's opinion, definitely could not be said that that justified the unrealistic claim made by the patient, and the complaint was dismissed. There is also a question once a problem occurs where the press comes into play, and sometimes there are various kinds of third-grade journalists who will try to demand money to suppress news. This has been asked me a number of times, and my advice usually is it doesn't help in any way. And best thing to do is when you get a phone call from a news reporter, note down the number, the reporter's number, name, email address, then answer and tell him I'm faxing or I'm sending on email my written reply to the sequence of events as happened today. Make sure you send it immediately after the phone call, and all this, the reply or the statement should have been pre-prepared, preferably with legal help. Once an event has occurred and you expect the press to come into the picture, don't try to answer offhand, don't try to pay money to the press people to suppress news, and try to get help of medical legal consultants. There are many doctors today who have good legal knowledge and who can guide even the advocates in a particular case of medical negligence. These are again various sections within IPC which can be used to defend against charges of criminal negligence. Section 92, act done in good faith for benefit of a person even without consent, is actually not a criminal offense, but unfortunately we are still far away from this protection which was originally envisaged by those who had formed the Indian Penal Code. So the last slide is how to face a legal suit like you faced your first marital fight, stoically and with resolve not to lose your first fight, knowing this was inevitable with or without fault of your own, and knowing that you will probably lose. Despite that, you need to fight this, and that is the way you should fight. Thank you so very much.
Thank you very much, sir, for this excellent talk, and it's cleared out a lot of concepts. Uh, there will be questions now in the WhatsApp group after we relay the webinar. So, looking forward to the questions. Thank you very much.